Traffic offenses. It's the reason we're here tonight. I am Tom Carr. I'm one of the partners here at Tully Rinckey. I am the head of the criminal practice area here. In a past life, I was an assistant district attorney, first of all in Brooklyn. Later in Delaware County, where I was the DWI prosecutor for all 26 courts or whatever it was. I was the bureau chief in the Rensselaer County DA's office, and I also worked at the State Assembly, where I was an assistant minority counsel and deputy legislative director. I've been doing criminal defense work on and off for, well, let's see, almost 6 years here and at various times before that. I'm also a New York State DCJS Police Academy instructor. So I teach at the Zone 7 Academy, which is down in Oneonta, teaching police officers how to correctly do things, although they don't always go as planned. Okay. Well, what we're going to talk about tonight are the statutory and procedural overview of traffic offenses. We'll get into the specific traffic offenses, which is probably where most of the interest is, preparing DMV forms and documents, and transactions with the DMV. Sometimes engaging in transactions with the DMV or dealing with the DMV is like heading into the 8th circle of Dante's hell. But we'll try to give you some pointers on how to best get through that. Quick question first of all. How many people here handle traffic cases either on a regular basis or occasionally? Okay, we have a few. And the rest of you, you're here because you either have got a ticket or you anticipate getting a ticket soon?
I just have to have some extra cards.
All right. Okay, let's start with the boring stuff. The statutory and procedural overview of traffic offenses. In New York, the VTL contains more criminal statutes than any other body of law except the penal law. If you are doing traffic cases on a regular basis, you need to have a copy of the VTL. This runs to about 800 pages. It's quite detailed, it's quite specific, and it contains not only traffic infractions, but also misdemeanors and felonies, depending on the circumstances. The vehicle and traffic law must be construed strictly. Can anyone tell me what that means? No, not all together now, one at a time.
Probably word for word, 0.08, failure to dim, but they have exceptions for that, U-turns.
Exactly. Exactly. Now, under provisions of the vehicle and traffic law involving offenses mala prohibita, the people are not required to establish any criminal intent on the part of the defendant. What does that mean? Well, what's mala prohibita? If anyone remembers their Latin. Mala prohibita means something is bad because it's actually prohibited. In other words, if there's a law saying you can't do X, then X is bad because there's a law that says you can't do it. It's different from malum in se, which is something that's bad in and of itself. Now, something that's mala prohibita, it's not inherently evil, or it doesn't involve moral turpitude. An example would be, say, speeding. Speeding isn't bad in and of itself. Obviously, it's mala prohibita, or malum prohibitum in the singular, because there's a law against it. If you went to Montana 10 years ago, well, it wasn't malum prohibitum because they didn't have speed limits on some of the roads out there. Now they do. What that means is that the prosecutor is not required to establish any criminal intent on the part of the defendant. So, if the cop pulls you over and says you're doing, 65 and a 30, he doesn't have to prove that you intended to do 65 and a 30. All he has to prove is that you were doing 65 and a 30. The procedure. For the purposes of prosecuting traffic infractions, the procedural rules for the trial of misdemeanors are applicable. However, a traffic infraction is treated as a misdemeanor only for the purposes of procedure. So, in other words, the normal court rules that would apply for a misdemeanor in the penal law will apply for traffic infractions. Now, probably the most significant sentence on that slide is the last one. Every court has a slightly different procedure. Just because you get a disposition in one court does not mean you get it in another. I would go a little bit beyond that. It's not just different courts, it's different towns, it's different counties. One of the most difficult things to keep track of is which counties and which DA's offices have specific policies. We all know Albany County has very rigid policies about DWIs because we see that in the paper, and dealing with them on a regular basis. They're very, very rigid. You get pulled over for a DWI in Albany County and you've got, say, a 0.14 or 0.15 blood alcohol content. They're not going to reduce that to a DWAI. You cross the river in Rensselaer County, you get arrested for the same blood alcohol content, you've got no priors, you're probably getting a DWAI. Is it fair? I don't know. A lot depends on which county you get stopped in. Saratoga County is becoming a little more rigid, not to the extent of Albany County. Greene County is, I wouldn't say lax, but they're certainly easier to deal with than Albany County. Even within counties, different courts, different judges have different policies. For instance, in the Village of Ravenna Court, the Thruway 87 runs through part of the village. If you get a speeding ticket in Ravenna, and it's, let's say, it's a 65 mile an hour, so if you get a ticket for 90 or more, the judge will move to suspend or revoke your license. I've seen him do it to people all the time. I've argued that he doesn't have the authority to do that, especially if the person pleads it down. If they plead down to a lower speed, or if they plead it down to, let's say, an 1110A, a failure to obey a traffic control device, that judge will still say, I'm suspending your license, you'll get a notice from DMV about the hearing. He's the only judge I know around that does that. Also, different judges have different bugaboos. There are some judges who are very adamant that they will not reduce a cell phone ticket or a texting ticket. They have no problem reducing DWIs or speeds or anything else, but cell phone or texting, they will not reduce it. So the important thing is to know, number one, the policies of the DA's office in the county, and number two, know the particular foibles of the judges. Jurisdiction. Most traffic offenses are going to go to the town and village courts. Anything that's a misdemeanor or an infraction is going to be disposed of either in the town or the village court, depending on depending on the area. As it says there, cities with populations in excess of 200,000 may delegate jurisdiction of traffic offenses to administrative tribunals. Really, we're talking about, New York City does that, but everywhere up here, it's either the DA's office, the town attorney, or corporation counsel that handles tickets. In Schenectady, Albany, and Troy, it's corporation counsel. Everywhere else, it's either an ADA or a town or village attorney. In those tribunals, burden of proof is clear and convincing evidence. And as it says there, geographical discrimination between cities does not affect unconstitutional deprivation of due process. So in other words, just because a city has a tribunal as opposed to a judge, the offender is not denied due process. Traffic infractions. They're unique to the vehicle and traffic law. Well, you wouldn't really expect to find traffic infractions in the penal law. And traffic infractions may rise to the level of a misdemeanor or a felony under the VTL itself. Okay, who can give me an example of a misdemeanor or a felony under the VTL?
Reckless driving.
Reckless driving is a misdemeanor.
AUO.
Aggravated unlicensed operation can be a misdemeanor or can be a felony. Aggravated unlicensed operation is where you're caught driving while your license is suspended, depending on the reason it was suspended. If it was suspended for failure to answer tickets, and if you've got 10 suspensions on 10 different dates, that makes it a felony. You might think that who could get 10 tickets on 10 different dates that they didn't respond to? Happens a lot more often than you think. Not just students. What we've seen recently is a lot of people are being prosecuted for, under penal law, for forgery or possession of a forged instrument, or basically what we've seen is people would apply for a driver's license, and predominantly it's coming out of New York City. A lot of time it's immigrants. They apply for a license, they rack up all kinds of suspensions, and then they go back to DMV and they apply for another license under a slightly different spelling of their name. That used to work, except DMV a couple of years ago got some new facial recognition software. And by running the pictures on the licenses, they were able to match up, oh, this guy applied for a license, but he had a license before that was suspended or revoked. Those people are getting arrested and charged with felonies, and they're all getting charged up here in Albany, because since DMV is headquartered in Albany, regardless of where in the state they actually applied for the license, because the DMV headquarters is up here, they're getting prosecuted in Albany. And the Albany County DA's office has gotten a grant from the Department of Motor Vehicles to prosecute those cases. So they have a dedicated ADA that prosecutes those cases. Another example of a felony under the VTL for an AUO would be if your license was suspended as a result of an alcohol incident, in other words a DWI or a DWAI, and you get arrested for another DWI while your license is still suspended for the previous one, that can rise the AUO up to a felony. Okay, definition of traffic infraction. This is in the VTL 155. Traffic infraction is not a crime, and the punishment imposed therefore shall not be deemed for any purpose a penal or criminal punishment, and shall not affect or impair the credibility as a witness or otherwise of any person convicted thereof. What does that mean? Well, it means if you got a speeding ticket 5 years ago, and you were convicted of the speed, and now you're a witness in the case, simply having a traffic ticket cannot be used as a means of impeaching that witness. It's not a crime. The thing about New York is once you get a criminal record, even if it's only for a Class B misdemeanor, you have that criminal record forever. There's no way to get a criminal record expunged in New York. There are a couple of ways to get around the consequences of having a criminal record. You can get a certificate of relief from civil disabilities, for instance, but it doesn't remove the underlying crime from your record. In fact, even if you get a governor's pardon, you still have the record, just that the pardon shows up on the record along with the underlying conviction. Also in the penal law, an offense which is defined as a traffic infraction shall not be deemed a violation or a misdemeanor by virtue of the sentences prescribed therefor. In other words, if there's something in the VTL for which a sentence of, let's say 60 days in jail is prescribed, that even though in the penal law something that has 60 days in jail would be a Class B misdemeanor, just because of the fact that you could get 60 days in jail on the infraction doesn't make that infraction into a misdemeanor. It's still an infraction. Penalties. A traffic infraction is an infraction. In other words, a violation is a violation unless somewhere else in the law deems it to be a felony or a misdemeanor. Really what we're getting at here is that you got to look at VTL 1800. That's what governs. Fines. Defendant failed to pay a parking fine. Parking ticket was then arrested. The court could impose an increased fine. The procedure has changed in the last 2 or 3 years in New York. It used to be you get a traffic ticket, you get a speeding ticket. There's a date on the ticket, must respond or appear in person in court on March 1st. Person doesn't mail in the ticket, person doesn't appear in court. So many people get tickets and they think, well, I didn't deserve this ticket, so they take the approach of, if I ignore it, it will go away. It never does. Used to be you wouldn't answer the ticket, you wouldn't appear in court. Your license would be suspended for failure to answer the ticket, and it would just sit there in limbo. Your license would be suspended, but the ticket would just be out there. At some point, if you responded to the ticket, you would have to pay a fee to lift the suspension that was imposed. It used to be $35, and you would still have to deal with the ticket. That changed a couple years ago. What will happen now is you don't answer the ticket, a default conviction is imposed on the original charge. It's kind of like motion for summary judgment. You don't answer it, there's a judgment against you. Same thing with the ticket. You don't answer it, they enter a conviction against you. So now you've got the conviction. There's going to be a fine and most likely a surcharge on that. If you don't pay the fine and the surcharge, your license gets suspended. The fee, the surcharge, not the surcharge, the fee to lift the suspension has gone up to $70. They doubled it. So now you've got the default conviction and a suspension, and we'll go through a little later how to handle or how to deal with default convictions. You should have in your handout there the different points on driver's licenses. And the points imposed for speed vary depending on how fast over the limit the person was written up for. So anything up to 10 miles an hour is 3 points. 11 to 20 miles an hour is 4 points. 21 to 30 miles an hour is 6 points. 31 to 40 miles an hour over is 8 points, and more than 40 miles an hour over the limit is 11 points. Also in there is the first one listed as speeding, where the how fast over the limit you were going is not indicated on the ticket. That's a 3-point ticket. And we'll get to that in a little bit. Reckless driving, 5 points. Failure to stop for a school bus, 5 points. And going all the way down to, 2 points for texting. This does not include all of them. If you were looking for all of the points imposed for VTLs, then this is the book to get. It's the McGill's Vehicle and Traffic Law Manual for Local Courts. This is put out every year by Donald McGill. He's a town court judge in New York. This is $8 and $3 shipping. One of the reasons you should have this if you're representing people on traffic tickets is every judge has one of these. And it shows you, it lists out the offense, whether it's a misdemeanor or an infraction. It lists the fine, the minimums and the maximum. If there's jail time allowed, the minimum and the maximum, the points. It also shows you the surcharge imposed in town and village courts and also other courts such as city court. It's a good reference to have. This way, if you get a client who says, well, you know, if I plead guilty to, I got a ticket for speeding going 20 miles over, if I get this down to a failure to obey a traffic control device in 1110A, you know, what kind of a fine am I looking at? And in that case, it's a maximum of $150 with an $85 surcharge. So, good book to have for $11, 8 plus 3 shipping. It's well worth it. Okay, specific offenses: unlicensed operation, speeding, and reckless driving. VTL 511. Operation while license or privilege is suspended or revoked, otherwise known as aggravated unlicensed operation. Obviously, license refers to someone within the state whose license has been suspended or revoked. Privilege is someone who has an out-of-state license, whose privilege to drive on that license in New York is suspended or revoked. For a 511, it applies where the person knows or has reason to know that his or her license is revoked or otherwise withdrawn by the DMV. What that means is, when you get your license, you give your address to DMV. It is therefore presumed that if DMV suspends your license, they will mail you a notification at that address. If you've moved and you forgot to change your address and you never got the notification from DMV, too bad. Doesn't count. If you move, you have 10 days within which to notify DMV of your address anyway. But even if you forget to move, if you never get the notification from DMV, the law's position is, too bad, you should have known. Why should you have known that your license was suspended? Because you got a ticket and you didn't do anything about it. That's another notification. Statute 511 defines 3 different crimes with penalties ranging from misdemeanor sanctions to an E felony. Degrees of offenses are based upon the circumstances surrounding the reason for the initial suspension or revocation of the license. We talked about that. How many suspensions you have. 3 suspensions on 3 dates would be a misdemeanor. 10 on 10 would be a felony, or a suspension or an arrest while driving on a suspended license the suspension being for an alcohol event, that would elevate it as well. Defense to 511. The operator of the vehicle at the time of the offense had a valid license issued by either a foreign country, a state, a territory, or a federal district. If you come here as a tourist from, let's say, Ireland, you have an Irish driver's license, you can drive in the state of New York, you don't need a New York license. An out-of-state license, you know, people from Jersey can come up here and drive, poorly, but they do. But their license is valid. Territory or federal district, pretty obvious. There's one other thing that's not listed there, but that does apply. If you are in the military and you have a license, your only license is a license issued by the military, that is still valid to drive in New York. However, if you're in the military and you have a spouse or a family member who has a license and the only license they have is issued by the military, for them, that's not valid in New York. One of those weird little distinctions in New York. Now, obviously, at any time, once you become a resident in New York, then you have to get a New York license. Limitation on pleas. This is something that works in theory but not in practice. Any plea accepted in full satisfaction of the charges, in other words, a 511 charge, must include a guilty plea to at least one of the offenses. A guilty plea to another section in satisfaction of VTL 511 will not be authorized. Technically, that's true. However, the rest of it says, if the DA determines the charges are not warranted, he or she can make a record stating the basis of determination, and the court may accept a guilty plea to another charge. Usually with a 511, assuming the person doesn't have 5 different suspensions on 5 different dates, or doesn't have a prior history of racking up AUOs or other traffic offenses, an ADA will probably reduce it to either a 509, which is operating without a license, or a 511A1, which is facilitating aggravated unlicensed operation. Technically, facilitating unlicensed operation means I loan my car to somebody who I know their license is suspended. I'm facilitating the AUO that that person is committing. But in practice, a lot of times someone charged with that aggravated unlicensed operation is going to get a plea down to a facilitating AUO. The 511 itself, the aggravated unlicensed operation, can be a misdemeanor or a felony, but the facilitating is only a violation, so no criminal record. Also, the fines are less. Speeding. Is there anybody here who's never got a speeding ticket? Really? There's only 2 kinds of people. Those that have got speeding tickets and those who have not yet got speeding tickets. Not yet. If you get a client that comes to you with a speeding ticket, you have to look at the section of law that it was written. What did the cop write down? For instance, 1180A, no person shall operate a vehicle or at a speed greater than is reasonable and prudent under the conditions and with regard to the actual and potential hazards then existing. With that one, it's usually not written with an actual speed. In other words, you won't see 75 and a 55 written down for an 1180A. What you would more likely see is an 1180B, which prohibits operating motor vehicles in excess of 55 miles an hour. Someone's doing 75 in a 55 mile an hour zone, chances are 1180B is what the cop is going to write. Now, if the cop writes 1180C for 75 and a 55, and you're driving, let's say, just north of the Twin Bridges where you're on 87, but it's a 55, Well, 1180C shouldn't apply because you're not doing it during school days between 7 a.m. and 6 p.m. This really is for school zones, 1180C. 1180D is the one that a lot of cops will write if you're driving in excess of the posted speed limit. So in other words, someone's doing 56 in a 45, you're probably going to see an 1180D. The 1180A you're going to see in bad weather if there's an accident. And it can be a one-car accident. When I was a prosecutor down in Delaware County, we had a woman who was coming down a big hill in January in the middle of a snowstorm. Her car spun out and wound up facing the wrong way on the other side of the road. She was none too pleased when a trooper pulled up and wrote her a ticket for 1180A. He said, well, obviously she wasn't driving reasonably and prudently in the weather conditions at that time. 1180A also applies even if someone is driving under the posted speed limit. And I've had clients who come to me and they don't understand it. They say, you know, it was a posted 45, I was driving 30 miles an hour, but I still got pulled over and I got a ticket. An example would be, let's say alternate route 7. It's a 65 mile an hour limit. During a bad snowstorm, if you're doing 55 and people are sliding off the road, 55 may not be reasonable and prudent, even in the 65 mile an hour zone. So a cop could conceivably still write a ticket for that, even though you're going under the posted limit. You've got to look at the subsection that was written. Question?
How would this also apply in the case where a driver is at the speed limit or below, doesn't fail to move over out of the way of, say, an emergency vehicle on the shoulder with flashing lights?
Mm-hmm. That's a separate offense. That's not speeding. That's failure to move out of the way of an emergency vehicle.
Yeah, but why wouldn't that be is reasonable prudent under the conditions? I mean, is it speed that counts there?
Well, when they say conditions, they're talking about really road conditions and weather conditions, not the condition of an emergency vehicle trying to pass.
No, I'm talking about on the shoulder.
Or even on the shoulder. I mean, the law now states that if there's an emergency vehicle pulled over on the side, then you have to move where possible, at least one lane out of the way. So they wouldn't really write you up for speed not reasonable and prudent in that circumstances. They would write you up for specifically failure to yield or failure to move over. There's a different subsection of the VTL for that.
Quick question, just real quick. If the cop makes the mistake and puts 1180C, and he should have used, say it wasn't a school zone.
Right.
It was something else. Is that something that you could use to dismiss?
You could. Here's the thing. You can use it to try to dismiss, but you're probably going to be better off using it to try to get a better offer. Because even if the case gets dismissed, there's nothing to stop the cop going out and writing the correct subsection. So, I've used that with prosecutors. I say, look, you've used the wrong subsection. They're like, okay, fine, I'll move to dismiss the charge and rewrite the ticket. It's like, well, let's save everybody the time, and how about a parking ticket? Okay, let's do it. We're done for the night. So that frequently happens with that. Let's see, where are we? Okay. 1180E, regarding intersections, railroad crossings, hill crest, narrow winding road, etc., etc. 1180F, authority given to agencies with highway jurisdiction to reduce the work area speed limit by as much as 20 miles an hour. That's those temporary signs you see on the road, like on 88 where it would be normally 65, signs up 55 limit. So DOT can put up those signs and that's legal. 1180G, directed at essentially commercial vehicles that have a radar detector. You can't go above 55 miles an hour or whatever the speed limit is posted.
Question.
Yes.
Let's say suggested speed limit, exit and entrance ramps, the yellow signs that say, let's say, 20 miles an hour, but that's not the speed limit, let's say it's 45 and 20 mile an hour, are those regarded as suggested?
They're not actual.
Permanent signs, not.
Yeah, they're warning signs. They're not really, you know, it's not like the white sign that says 55 or 65. I've never, in, what, 16 years of doing this, I've never seen a ticket written for someone going faster than the posted speed on the curve. And you know what, I mean, personally, I think if you try to obey some of those speed limits, like getting off, you know, 87 or 88 or 90, you're going to wind up with someone else's car in your back seat, the guy coming behind you.
I've never had a case where this was the issue, but it would occur to me that it could be the basis for law enforcement to officer to write a ticket for 1180A.
Exactly.
If it's snowy conditions and the suggested speed limit on the exit ramp is 20 miles an hour, and for some reason he's able to determine that you were doing 30.
He wouldn't even have to discern what you were going. If you slid off on that curve going off, he can write you up saying, well, obviously, you weren't driving at a prudent or reasonable speed. So, yeah, you could get a ticket for that.
Is there any requirement that speed limits be posted at certain intervals on the road?
Not at certain intervals per se. You know, where the speed limit changes, it has to be posted. And also, when you're coming into, let's say, a village or a town, you have to have that sign that says, you know, speed, what is it? Speed zone ahead. That has to be posted a certain distance before the actual speed. So you're not just driving along at 55 and all of a sudden the first warning you have is the 30 mile an hour speed and there's a cop sitting on the other side of the ticket going, can't do that. They have to give you a warning that there's going to be a change in the speed limit.
We're doing a quick Q&A, I'm sorry. I just have one more question. So what if you could see the sign, the speed limit's going up, right? At what point does that actually become the speed limit? So say you go from
Once you're past the sign.
once you pass
Level or past the sign.
Okay, so it's not that it's in your view, in sight. Okay.
Nope, nope. I actually had that down in Delaware County. A girl was 20 yards before the sign. If she was in a 30, it became a 55. She was speeding up. She got tagged for 46 in the 30. She was within, even the cop admitted it, she was within 20 yards of the sign. You know, the speed limit is 55 down there, not here. Here it's still 30. Okay. The 1180s that we've gone through there, should include 1180A on there as well, include fines, imprisonment, or both. But G, the last one, which was the commercial vehicles, is punishable with misdemeanor, fine, or imprisonment, or both. Speed contests and races, in other words, two people drag racing, that is not as simple as a straightforward speeding ticket. If you're observed by the cops, they have evidence that you're drag racing someone else, and you're convicted of it, it's going to be a misdemeanor, not a traffic infraction. And the fines are also increased. Just as a quick example, the fines for a regular traffic ticket in 1180B, for a first offense, if you're 10 miles or less over the speed limit, the minimum fine is $45, the maximum is $150, and there's an $85 surcharge. First conviction for a speed race, it's a misdemeanor, and the fines are more than double what the fine range is for a straightforward speed. Okay, reckless driving. We seem to have lost part of the background of the slide on this one. But reckless driving, using any motor vehicle, motorcycle, or any other vehicle propelled by any power other than muscular power, so you're not going to get a reckless driving on your bicycle, or any appliance or accessory thereof in a manner which unreasonably interferes with the free and proper use of the public highway or unreasonably endangers users of the public highway. Reckless driving is a misdemeanor, and it quotes a case there that says you can be driving recklessly without being intoxicated, or you can be intoxicated without driving recklessly. Used to be, you got arrested for a DWI, a lot of DA's office would allow the person to plead to a reckless driving as opposed to a DWI. It's still a misdemeanor, but it doesn't have the consequences on your license that a DWI does. However, I know of no DA's offices that do that anymore. Generally speaking, once you're charged with an alcohol offense, it's going to wind up with some form of an alcohol conviction. For reckless driving, all information on the alleged violation must state sufficient facts to constitute the crime charged. In other words, they have to have sufficient evidence in there to show that you were driving recklessly. General information, just saying the person was reckless, will not be satisfactory. Goes back to what I said before, malum prohibita versus malum in se. Reckless driving will be malum in se. The acts and omissions constituting the crime must be specifically charged in the information with the same clarity and exactness as in an indictment. In other words, if the act or the omission, whatever constituted the crime, is not sufficiently written up, you can move to dismiss. If you're acquitted of reckless driving under the VTL, they can't try to recharge you under the penal law. Does not mean speed alone. Other circumstances are included which show a reckless disregard of the consequences. In other words, even if you're not speeding, but you pull out into oncoming traffic to try to pass someone on a curve, on a hill, or even on a straight road, causing other drivers to swerve out of the way, even if you're under the speed limit, that could be constituted as a reckless act. The last thing was that there must be evidence that the defendant drove the car in a manner showing a wanton disregard of the rights and consequences of using the public highway. 1102, obedience to police officers and flag persons. No person shall fail or refuse to comply with any lawful order or direction of any police officer or flag person or other person duly empowered to regulate traffic. So, in other words, you see one section of the road closed down, it's turned down to one lane, and you've got the guy with the flag, and the guy at the other end with the flag. They're directing traffic, and you just say, I don't know who that guy is, I'm not going to pay attention to him. You could be charged under 1102 for that. Now, what I've seen with cases like this, under this charge, is traffic lights. Someone will have a red traffic light and they stop. And there's a flag person there saying, waving them on. Which governs? Flag person, exactly. But I've had people who, the converse is true too. They have a green light and there's a flag person waving them down and they're like, I got the green light, and they drive right past. And they get pulled over because there's a cop sitting off to the side. And they're like, but I had a green light. In that situation, the guy with the flag trumps the traffic light. And as it says there, school crossing guards are included as within people duly empowered to regulate traffic. 1110, obedience to traffic control devices. Must obey a traffic control device unless otherwise directed by a traffic or police officer. And it's not enforced when the official sign is not in proper position or legible. In other words, if there's a speed limit sign and a tree has grown out and is completely blocking that speed limit sign, if you can't see it, then they can't prevail in a charge for an 1110, assuming, of course, you can prove that you couldn't see the sign because it was blocked. 1110 is a pretty common charge for a speeding ticket to get pled down to. An 1110A has 2 points, as opposed to a traffic ticket which can have anywhere from 3 to 11 points depending on the speed. (1174A), failure to stop for a school bus. A vehicle must stop when the red stop sign on the bus is in operation and the bus is stopped. First offense 250 to 400, etc., etc. So they're laid out there. This ticket is one of the most difficult to plead down. Even if you get an ADA that's willing to plead it down, a lot of judges will not go along with it. I know Judge Crummy over here in Colony, this is one of his bugaboos. So let's move on to DMV forms and documents. DMV, like any other bureaucracy, has a plethora of forms. However, we're just going to touch on a few tonight. The abstract request, the application to reopen a default conviction. I've gotten some questions about that. An appeal form, parent withdrawing consent, and the drinking driver program application. An abstract request. What is your driving abstract? Your driving abstract is basically, in written form, a copy of your driving history. It's going to have your personal identifying information, your name, your address, your date of birth, your license status, valid, suspended, or revoked, what class it is, in other words, what class of license you have. Is it regular license, CDL, motorcycle, whatever. Any restrictions, such as, corrective lenses, or if restrictions as to what kind of vehicle you can drive, or specific times you might be able to drive, like on a junior license, and the expiration date. It will show your driving history. So it will show when your license was issued, and any convictions or any adjudications that are on your license in the last, generally speaking, about 10 years. It will also show alcohol and drug convictions on there. Most, but not all, courts have access to DMV to run driver's abstracts. So you get a client who says, I have a speeding ticket in such and such a court, and you go to the court. Most of them have the ability to run an abstract. Some of them do as a matter of course. The court clerk will hand a copy of the ticket, the plea of not guilty, and the driver's abstract to the prosecutor, be it an ADA or a town attorney. However, there are some courts that don't do it. They don't want to pay the fees, they don't want to use up the paper. So I always tell my clients, you have to get me a copy of your abstract. There's another reason for that. I want to know what's on their driving history before I go into court. I don't want to go into a situation where the ADA knows more about my client's history than I do. I've had some indicators in talking to clients. For instance, question, do you have anything on your license? Not really. Not really means yes. I don't know often means yes. Generally, the ones that you know are a clean abstract are the persons that say very indignantly, I have been driving since 1962, I never got a ticket. Of course I've got nothing on my license. Okay. I still ask them to get an abstract. Let me go back to the abstract for a minute. There's two ways to get your abstract. You can go into a DMV office, fill out a form, and you pay $10, and they will give you a copy of your abstract right over the counter. That used to be the easiest way to get them. You used to be able to order it online, and they would mail it out to you. It was also $10, and it would take anywhere 2 to 3 weeks to maybe never to get the abstract. I've had a couple of clients that ordered it and never received it. However, since last year, You can now log on to DMV, go into the My DMV section, and download and print out a copy of your driver's abstract. And for doing the work yourself, they only charge you $7 for it. That's the fastest way to get it.
How do they know it's you?
Well, they ask you, it has to be your name, your address, date of birth, your driver's license number, all that has to match up. Now, could you find my license and get that information? You could, but in order to download it, you have to create an account on DMV. So if there was an issue, there is a mechanism where they can backtrack and see actually who downloaded it.
Can the attorney do it for the client, or that's not permissible?
Well, the attorney can do it for the client. There's certain reasons why you can get an abstract, and one of them is an attorney doing it for a client. Can you go into DMV or go online to DMV and order one for, your buddy just because you think, hey, Frank, I think has a lot of tickets. I'm confused. I'm interested. Does he have, not a good idea to do that. That's not a legal basis to get someone else's abstract. An application to reopen a default conviction. Now, this is with DMV. Yeah.
So if the client, you tell your client to get the abstract and they just don't do it, you're saying you can't do it, just photocopy their license, you got one?
Oh, you could do it.
No, I'm just meaning the general practice, you can't, it's not, attorneys don't generally do that. is
No.
what you're saying. And
No.
why not? It sounds much simpler to me.
Bec-
Charge the client $7 and you have it.
Because we're dealing with DMV. So first of all, you have to go into DMV and create an account.
Right.
And even that in and of itself is going to take 15 minutes, just creating the account. And then you download it. Now, the next time you're doing it for somebody else and you try to do it on the same account, I've known people who've had problems with DMV kicking them off and saying, no, you're not authorized to get this.
Well, I'm just thinking every time write a new account and then it saves you
Yeah.
that whole hassle when you're just done.
You can, yeah, absolutely, you can do it,
Nothing wrong with doing that.
I mean, there are certain documents that I ask my clients to provide me with, and one of them is an abstract.
Right.
And this way they see it before I see it, so I don't want a situation where I print off someone's abstract and I go to court and then they're like, oh, no, that's not right, because it's the first time they've seen it.
It's not unethical to do that.
No, an attorney can always get it for their client.
Does ACOD show up on the abstract?
An ACOD would not show up on the abstract, assuming that the person had answered the ticket, because just getting a ticket, an issuance of a ticket is not going to show up in the abstract. It's either a conviction or a failure to respond to a ticket or a failure to pay a fine. So as long as someone responds to the ticket, that's not a trigger for it to go onto the abstract. With an ACOD, adjournment and contemplation of dismissal, once the period of the adjournment has passed, be it 6 months, say, and the case is dismissed, well, now the ticket is dismissed, so there's no basis for it to be on the abstract either. So, no, it shouldn't show up there. Because of the change in the law and now the default convictions, DMV has in place a mechanism for reopening a default conviction. And basically, it says, you have to prove that you're not guilty because, and give valid reasons, and you did not respond to the ticket and give a valid reason for that. Let's see here. And that form is also in your packet.
Can the attorney still do a 440 form number?
Yes, and that's what I'm just going to get to in a minute. I think, personally, rather than dealing with DMV, the way I prefer to handle these cases is to go back to the court and to do a quorum nobis. And I've yet to come across a judge who says, I won't do it. Most of them will entertain a quorum nobis, get the case back on the calendar, and then deal with the ADA or the town attorney, whatever it is, just as you would with any other ticket. The only other wrinkle with it is if a default conviction is entered, chances are your client's license is suspended. So you've got to deal with this underlying suspension on the license and pay the $70 suspension lift fee in order to clear up the underlying suspension and deal with the original ticket. Now, as it says at the bottom there are specific requirements if you're challenging convictions for either operating without insurance, an unlicensed operation, or an unregistered vehicle. And they're also contained in your packet of materials there. For an operating without insurance, you need an original letter from the insurance company. Something from your broker is not good enough. It has to be an original letter. It can't be a photocopy or a fax. It must be on the company's letterhead, and it must state that the vehicle was insured on the date that the ticket was issued. The letter must also be signed by some, functionary of the insurance company, and it must contain the vehicle make, year, and the VIN number so that DMV can match it up and say, okay, it looks like there was insurance in effect. For an unlicensed operation, you need a copy of your driver's license that was valid on the date the ticket was issued, or documentation from motor vehicles verifying that you had valid driving privileges on the date the ticket was issued. This goes back to the defenses we spoke about earlier for a 511. If you had a valid license from a foreign country, state, territory, federal district, or the military. And for an unregistered vehicle, a copy of the vehicle registration that was valid on the date the ticket was issued, or documentation from Motor Vehicles Office verifying the vehicle in question was registered on the date the ticket was issued. One thing that I've come across with the unregistered vehicle is someone will say, I got a ticket for an unregistered vehicle, but here's a copy of my registration showing that my vehicle was registered on that date. Well, if for some reason DMV suspended your registration or revoked your registration, then it wasn't actually registered on that date. So that's another reason to get to make sure that you have someone's abstract so you can see, was there anything that would give rise to a suspension or a revocation, not only of a license, but of a registration? Was there something else that they did that they shouldn't have done? Going back for a moment, in your packet there before the application to reopen a default conviction, there's a list of the reasons why you can request a copy of a driver's abstract. And it lists, I don't know, maybe 15 reasons why you can request an abstract. And the first one there is use in any civil, criminal, administrative, or arbitral proceeding in any court or agency, including service of process, blah, blah, blah. That's the one you want to check off if you're ordering the abstract for your client. Okay, after the application to reopen default conviction, we've got an appeal form for the DMV. They have very hard and fast dates within which this has to be done. It has to be done within 60 days of the date of the penalty order, or if there was no penalty ordered, if there was a decision letter or a notice that was received, it has to be within 60 days of the date of that letter or notice. And the it's pretty self-explanatory here. What's being appealed? Was it a license or a penalty action? Was it an application denial? Or was it something else, like a chemical test refusal, persistent violator, etc.? So let's say you have a client who was pulled over for a DWI, refused the breathalyzer back at the station. At the arraignment, their license is going to be suspended. They're going to get a notice from the judge of a DMV hearing. What frequently happens is DMV hearing is scheduled. You show up with your client. You sit around for an hour and a half, and the cop doesn't show up. The judge will say, and it's an administrative law judge, will say, okay, your privilege to drive, your license is restored. However, we're going to adjourn the hearing and give the officer another chance to come in. Sometime within the next 3 months, maybe 4 months, you'll get a date for a new hearing. You go for the new hearing, the cop shows up, and your client winds up with the judge saying it's a valid refusal and I'm suspending your license for 6 months. It's where the appeal form comes into play. You can appeal, it says there under what is appealed, the chemical test refusal.
Tom, is it 6 months or a year? The refusal.
It's a year, you're right.
What's there to appeal though? Refuse.
We're all attorneys here. Is anything ever that black and white?
Whether it's a public highway, reasonable cause for the
You know.
rights read, and all that stuff.
Actually, there was an interesting case, I think it was last September or October out of New York City, where there was a refusal hearing, and the officer showed up, and apparently he was having some difficulty getting through his testimony, and the judge was essentially coaching him through his testimony, and at the end of it found that it was a valid refusal. Well, that case wound up with actually in Article 78, and the decision was that the judge had no longer been an impartial judge in the case, and in effect he became an agent of the prosecution, and the refusal, the suspension based on the refusal, was overturned.
Twice you've used the term valid refusal. You mean the other opposite. It was not a valid refusal, and it was held against the licensee.
Well, from DMV's point of view, and that's why I use the term valid refusal, because that's the terminology they use. What they say is, well, was the charge of refusing the breath test, was that a valid charge? But the shorthand they use is it's a valid refusal. There's no such thing as a valid refusal. You know, you can't say, well, you know, okay, you were correct to refuse the test. That's not what we mean. What it means is where the processes followed.
Okay, no,
Yeah.
terminology, it's terms
Right.
of art, okay.
Yeah, but just let me just finish on that. Basically, the DMV judge has to find a couple of things. He has to find that there was reason to ask you to submit to a breath test, that you refused the breath test, that the officer informed you of the consequences of refusing the breath test, in other words, that your license would be suspended, that he asked you again to submit to the breath test and you refused. That's what the officer has to show, and that's what the judge has to rule on to say it's a valid refusal. Parent withdrawal of consent. This allows a parent to withdraw their consent for the issuance or reissuance of their child's driver's license or learner's permit. Can be withdrawn for any reason, provided that the child is under 18 and they have either a learner's permit or a junior driver's license. A lot of people, I think, don't know that this exists, and they think that once their kid has a license that there's really nothing they can do about it. To be perfectly honest, I think there are some people that should do this more often, judging by some of the tickets that I've seen. But like I said, a lot of people don't know it's out there. And it's good to let people know that they have that option.
Question, small minority of cases, I've never had one involving it, but emancipation considerations, I know it's kind of young, but occasionally.
What's your...
If, let's say, a 17-year-old is deemed to be in New York State legally deemed to be emancipated.
Right, then it wouldn't apply. Drinking driver program application. Someone convicted of an alcohol or drug-related driving violation, in other words, VTL 1192, 1, 2, 3, or 4, may be able to obtain a conditional driver's license for the limited purpose of driving to and from school, work, and certain other activities. Certain other activities includes medical treatment or, counseling if it's part of a plea deal. May not obtain a conditional driver's license to operate a taxi cab or any CDL vehicle. Now, if you have a commercial driver's license and you get arrested for a DWI and you're convicted of a DWI, but you're not driving a commercial vehicle, you can still get a conditional license. It's just not valid for your commercial vehicle. So you can drive your regular car on a conditional license, but not the commercial vehicle. There are a number of restrictions with this. If you have completed the DDP and gotten a conditional license at any time in the preceding 5 years, you're not eligible for another conditional license. In order to get a conditional license, you have to enroll in the drinking driver program. In practice, what normally happens is this. Your client goes to court, you work out a deal with the DA. Let's say your client pleads to a DWAI, 1192-1. Mandatory 90-day license suspension. They haven't had a conditional license before, so they're eligible for one. So you go to court, you ask the judge for a 20-day stay of the suspension. So within those 20 days, your client has full driving privileges. And the purpose of the 20 days is to give your client time to go to DDP, for the court paperwork to reach DMV, for your client to go to DMV and enroll in the drinking driver program. At the end of those 20 days, your client's license is suspended, but if he's enrolled in the drinking driver program, DMV can give him a conditional license. Now, here's one of those situations where what the law says and what DMV does are two different things. The law says it's a mandatory 90-day license suspension for a conviction of a DWAI. The drinking driver program is a 7-week course. What usually happens is once you complete the drinking driver program, DMV gives you your full driving privileges back. So do the math. 7 weeks, 7 days in a week is 49 days. So within 50 days of the suspension, your client gets their license back, even though the law says it's a mandatory 90-day suspension. I mean, let's face it, as defense attorneys, we're not going to complain about that because our client is getting their license or their privilege back sooner. There is a copy of the drinking driver program application also in your packet there. Frequently, I have clients will plead out, they'll get the 20-day stay, and they'll say, first thing tomorrow, I'm going to DMV to sign up for the drinking driver program. I tell them don't waste your time. Because you go to DMV and DMV will be saying, we have no record of this, we haven't received the paperwork from the court, there's nothing we can do. What I normally tell my clients is, you know, if it's like let's say it's a Tuesday or a Wednesday, I say if you don't hear from DMV by the middle or the end of next week, call them up. But it's going to take on average 3 to 4 days for the court to get the paperwork over to DMV and for DMV to realize that they have the paperwork. DMV is actually coming on in leaps and bounds in terms of, I don't want to say customer satisfaction, but being a little easier to use. Many transactions can now be completed over the phone and online, and the websites are up there. You can just Google them. What a lot of people don't realize is that some of the call centers for DMV, there's one down in Greene County, for instance. It's at the Greene Correctional Facility. It is staffed by inmates. So if you're calling up DMV, you may well be talking to somebody who's in state prison for who knows how long for whatever felony conviction. A couple of people that I told that to turned pure white and said, I'm never calling DMV again. Address change. This, I think I mentioned this earlier. If you do change your address in New York, you have 10 days within which to notify the Department of Motor Vehicle. And if you look at your license, there's a little box on the back of the license. It's in the top right-hand corner. It says enter address change, and underneath that, you must notify DMV within 10 days. Can be done on the phone, internet, mail, or in person at a DMV office. The problem with not notifying DMV of the address change is, number one, it's a separate offense. And number two, if for some reason something occurs where there's an issue with your license and DMV is going to send out notification to your old address, which may or may not get to you. One of the more common ones I see where people have issues with this, where they're not really culpable of anything, is they change insurance companies. And the old insurance company notifies DMV that we're no longer insuring Joe Smith, and either the new company hasn't informed them or DMV fails to match up the two records. DMV will then suspend that person's license and send out a notification to the old address. Then you get pulled over, you're getting a ticket for an AUO, and we're off to the races. As I said, the abstract can be requested online through, as I said, mydmv.ny.gov if you create a specific account to do that. Restoration after revocation. This is something I've seen fairly often. Someone will get a, let's say they plead guilty to a DWAI, they get a 90-day license suspension, they say, I don't want a conditional license, I don't want to put off the suspension starting, you know, let the suspension run. So they count on their calendar 90 days, and on the 91st day they get back in their car and they're out driving. They go to a red light, they get pulled over for speeding, and all of a sudden they get a ticket for AUO. And they're like, but the 90 days was up. It's DMV. You have to feed the beast, you have to pay a fee. So even if the suspension has run, you still need to pay a fee to DMV to restore your privileges. The same applies for a revocation. Now, difference between the two is the suspension will suspend your driver's license for a period of time, after which point it's restored upon payment of a fee, whereas a revocation will completely, it revokes your license. Your license is gone, you got to apply de novo. If you want to restore or apply for a new license after being revoked, you have to wait until the revocation period has been completed if you're going to go to the DMV office to apply, or 30 days beforehand if you reapply by mail. You pay all the reapplication fees and other monies owed to the DMV, which can include the driver responsibility assessment that we talked about. Clear any current suspensions, or you can reapply online by submitting the form MV44, but you still have to pay all the reapplication fees and other monies and clear any current suspensions. Registration can be renewed online or through the mail or at your DMV office. And one thing I'll say about DMV transactions, the county in which you complete your transactions can get a portion of the money that you're paying. So, let's say you live in Rensselaer County, but you work in Albany County. Well, if you go to DMV in Albany County to renew your registration or whatever, Albany County gets a percentage of that money, whereas if you go to your home county, they get a percentage of the money.